Okay, folks, let's get started. Defense lawyers hear this question all the time. How can you represent those people? And they've answered the question for decades, even for centuries. There are some common themes to their answers, but there's also interesting variety in the answers. Notice it's plural, it's not one answer, but several different approaches to dealing with this question. Now, some of the answers stress the collective duty of all lawyers to perform this function. Other answers argue for the right of individual lawyers, if they choose, to take such cases. Some answers, on the one hand, emphasize accuracy in fact finding. If you do this, it will contribute to more sound outcomes closer to the truth. Others emphasize some different non-truth finding benefits of representation. Let's take a quick look around the historical landscape at these answers to the question, how can you represent those people? Let's look way back to an early example of this style of argument from Lord Erskine, who's a famous attorney, English attorney, represented Thomas Paine in his criminal trial for publishing scandalous and critical pamphlets critical of the government. Along the way, he explains why he took the case, and his answer speaks to the bar as a whole. Lawyers owe it to the bar. All lawyers owe this duty to the bar as a whole. Clients benefit incidentally. But you want a healthy system regardless of the outcome that you might foresee for today's case. So he would say, take the choice away from the individual lawyer. You just have to take these cases, even though they're unpleasant and 1,000 difficulties repel you from taking the case, but you have a duty. You have to. He also invokes the idea of impartiality or impartial justice, and part of that idea is the idea of accuracy. So if the advocate refuses to defend, he says, then he assumes the character of a judge before the hour of judgment and perhaps puts his reputation, and for Lord Erskine it was his, of course, puts his reputation behind what is perhaps a mistaken opinion. Now we get the classic American answer to this question from a report from the American Bar Association from the 1950s. This is sort of the establishment answer on this question, or collection of answers, put together by Lon Fuller, pictured here, a Harvard law professor, as well as John Randall, the president of the ABA. So here we shift from an invocation of the lawyer's duty to the system into an argument for individual conscience. The individual conscience of the lawyer ought to lead him or her to take on these cases every so often. And it's an account of human decision making. The ABA warns against the human tendency to premature cataloging and says that adversary presentation of evidence is, I think they would say, the only way, but certainly a powerful way to resist this temptation to judge too swiftly the things that are not yet fully known. And the bar says, the ABA says, that this service by a lawyer is especially valuable if you're representing somebody who represents an unpopular cause, because in that setting, for the unpopular position, a fear arises, says the bar, that perhaps more might have been said for the losing side, and suspicion is cast on the decision reached. So we don't want to look back later and say, we could have done more, we could have listened better, and we didn't. We want to sort of move ahead with our judgment with a clear conscience that we've done everything we can. Now, Abraham Lincoln offers a very cagey, insightful view about human capacity. He says, you really ought not impose this duty on all of us, because not all of us can be effective for the client if we don't have at least some level of belief in their innocence. So we have a couple of historic examples of Lincoln turning to co-counsel at the end of the trial and saying, I think the guy's probably guilty. You better do the closing, because they'll just read my face instantly. The jury will. So it's not so much that Lincoln says, I shouldn't do this as a matter of ethics. It's just that as a matter of efficacy, as a matter of being a good lawyer for the client, some people can't pull this off. Notice that all of the accounts depend on role differentiation, the idea that this makes sense for a defense lawyer in the context of a system where other people are doing other things, and it's part of a multi-actor system. So the judge is judging, and the lawyer shouldn't become the judge. Shouldn't become the judge too early. There's a judge that has a function and a time in the process, so don't do somebody else's job. The prosecutor is going to be out there, and so somebody has to do the defense side of this function. Angela Davis, from an essay written in 2013, gives us an interesting answer that really is not necessarily grounded in accurate fact-finding for a particular case. Instead, she says, okay, as I play this particular role, I'm aware that this is part of a large system where the prosecution, the state, has enormous resources. And so I just need to be there to speak for a defendant, given the power imbalance. That's good for the defendant. It's also just good for society for us to see that it is a good thing to hold government to account. My client is the Constitution, is the way that people sometimes put this. And so it's a government accountability argument that really doesn't relate so much to truthful fact-finding in particular cases. It's more of a systemic argument. And then finally, Davis says, I'm here to speak for a broader view than just trying to reconstruct what happened on a particular day, the day of the crime. My job is to put that day into a larger context. And so I need to remind you that this defendant got here over a long time with a lot of things happening. I need to point out to you that this may have been the worst day of the defendant's life, but that it's not the only day that counts. And finally, defense attorneys are not the only people who face these sorts of "why do you do this stuff?" question. Prosecutors sometimes face the same question. How can you do that, particularly among prosecutors and their social circles, if they believe that something is amiss in criminal justice system that has relied more and more heavily over the past few generations on prison, something we sometimes call mass incarceration, where the effects of the system are primarily felt in poor communities and in communities of color. So in that world, if a prosecutor is worried about that differential impact, that disparate impact, can a good person be a good prosecutor, to put it in the sort of pointed way that Abby Smith, the defense attorney pictured here, poses the question? The classic answer to this is, well, a prosecutor doing the job right can do more good for a community and for either falsely accused or disproportionately punished defendants. The prosecutor can do more good for those problems than any defense attorney might, because the prosecutor can just dismiss the case if it's an inappropriate case. A second line of response that I often hear in talking with prosecutors is the idea that I'm representing victims. Not exactly representing in the sense of they're a client, because the client is the people. The prosecutor's client is all the people of the jurisdiction. But in a looser sense, there has to be somebody to speak for a victim. These victims themselves are very often coming from poor and disadvantaged circumstances, and there should be somebody to speak for them, just as there's somebody to speak for the defendant. So it's again a kind of role differentiated. Somebody's got to be there to do this piece of it, and I trust the entire system to create just outcomes. So that gives you a sense. I won't try to tell you, whether these answers are sufficient for any one person, or certainly not tell you whether it's sufficient for you, but it gives you a sense of the variety of answers that one often hears and that we have heard over time to these questions. How can you do that? Questions posed both to defense attorneys and to prosecutors.
Stand by me.